On 24th of the February, President Putin declared a war against Ukraine. He started missiling, shelling several Ukrainian cities. Now, it is very important to draw an outline on the international armed conflict, international human rights law, humanitarian law, and what basically is the role and the take of the international law in the current situation. Now, there are two terms which are interchangeably used. First one is a war, and second one is invasion. So, these two terms are interchangeably used in the current scenario. But which is the right term we should use for the current scenario? Now, let's start by defining these two terms. Now, a war basically is a large scale armed conflict between countries, national ethnic groups, or sizable groups, usually involving the engagement of military forces, while invasion, on the other hand, is a military action consisting of armed forces of one geopolitical entity entering territory controlled by another such entity, generally with the objective of conquering territory or altering the established government. So, invasion has basically two objectives: either they want to conquer the territory or they have to establish or alter the established government. So, going through these definitions, I am convinced that this is not a war. So, now this is an invasion by Russia on Ukraine, and Ukraine retaliated in self defense. Now, let's go a few days back to know what is the current scenario. So, the Russia's parliament adopted a resolution on February 16, 2022, requesting President Putin to recognize as independent states two areas in eastern Ukraine held by the Russian backed armed group. On February 26, President Putin signs two decrees recognizing two areas' independence and submitted them to the parliament for the ratification. Following that, he issued orders to Russia's armed forces, which have been amassing at the borders with Ukraine for months, and to carry out peacekeeping in two self proclaimed areas. On February 22nd, the Federation Council, the upper chamber of the Russia's parliament, approved the Putin's request to deploy the armed forces. Now, what international law governs an armed conflict between Russia and Ukraine? So the hostilities between Russian armed forces and Ukrainian armed forces constitute an international armed conflict governed by the International Humanitarian Treaty Law. Primarily, the Fourth Geneva Convention 1949 and its first additional protocol 1977 Protocol 1 and the Hague Convention 1907 regulating the means and the methods of the welfare as well as the rules of the customary international law. Now, both Ukraine and Russia are parties to the 1949 Geneva Convention and Protocol 1. So, what kind of military attacks are prohibited? So, any kind of direct attacks on civilians and civilian objects as discussed above are prohibited. The law of war also prohibit the indiscriminate attack. So the indiscriminate attacks are those that strike military objectives and civilians or civilian objects without distinction. Examples of indiscriminate attacks are those that are not directly at the specific that are not directed at the specific military objective, or that use weapons that cannot be directed at a specific military object. Now, the prohibited indiscriminate attack include areas bombardment, which are attacks by artillery or other means that treat as a single military object or objective. A number of clearly separated and distinct military objectives located in an area containing a concentration of civilians and civilian objects. The military commanders must choose a means of attack that can be directed at the military target and will minimize incidental harm to civilians. If the weapons used are so inaccurate that they cannot be directed at the military targets without imposing a substantial risk of civilian harm, they should not be deployed. The attacks that violate the principle of proportionality are also prohibited. An attack is disappropriate if it may be expected to cause incidental loss of civilian life or damage to civilian objects that would be excessive in relation to the concrete and direct military advantage anticipated from the attack. Now, anti-personnel landmines and cluster mines or munitions are prohibited by the international treaty and should never be used because of their inherent discriminate nature. One more bullet which bends after it has been shot down, that is also prohibited under the international treaty and law, because if you take out that bullet because of the pointy edge, it will cause more harm to the person. So these ammunitions, these landmines are prohibited. Now, are the parties to the conflict permitted to target infrastructure such as airports, road and bridges? Now, in the current ongoing situation, you will be seeing a lot of news that helipads or airports are being targeted. Some of the civilian buildings are targeted. So, what is the basic take of the international law whether some civilian infrastructure like airport roads can be targeted or not? So, civilian airports, roads, and bridges, these are all civilian objects that become a military objective, subject to the attack if they are being used for military purposes of or military objectives are located on or within them. Even then, the rule of proportionality applies. So, the rule of proportionality is very important, which requires the parties to the conflict to weight the short and the long term harm on the civilian against the expected military advantage of attacking them. They must consider all ways of minimizing the impact on civilians, and they should not undertake attack if the expected civilian harm outweighs the anticipated military advantage. Now, I saw a couple of news articles whether some of the countries are preparing to protect themselves with cyber attacks, or one country uh, is saying that they will do a cyber attack on the other country. So, what is now the legality of the cyber attacks in the international law? Now, computer network attack or the cyber warfare are not specifically addressed in the Geneva Convention, but the basic principles and rules on the methods and means of warfare remain applicable. Cyber attacks must target military objectives and be either discriminate or disproportionate. For example, an attack on an electrical grid that causes long term harm for the civilian population is likely to be unlawfully disproportionate, whether carried out by airstrike or cyber warfare. Prohibitions on perfidy, collective punishment, and reprisals against civilians remain applicable. Now, fundamental rights are at stake when governments engage in cyber attacks or cyber warfare. In 2015, the UN General Assembly endorsed a report by an appointed group of government experts, UNGGE, that sets out a consensus view on the applicability of the international humanitarian and human rights law to cyberspace and includes commitment to the norms for state behavior. These norms include not conducting or knowingly supporting information and communication technology (ICT) activity that intentionally damages critical infrastructure or otherwise impairs its use and operations to provide services to the public, as well as not knowingly allowing their territory to be used for international wrongful acts using ICTs. Recently, a parallel UNGGE report has flagged examples of critical infrastructure providing essential services to the public to include not only hospitals but also energy, water, and sanitary, education, and finance services. Now, an important question arises regarding the international judiciary. Can any war crimes, or crimes against humanity committed in Ukraine be tried before the International Criminal Court? So, broadly, Russia and Ukraine are not members of the ICC, but Ukraine accepted the court's jurisdiction over alleged crime committed on its territory since November 13, and in so doing, the obligations to cooperate with the court. In December 2020, the ICC Office of the Prosecutor concluded its preliminary examination and announced that the criteria under the ICC's founding treaty, the Rome Statute, had been met to open a formal investigation, but it has not yet requested permission from the court's judge to formally open an investigation because ICC is a court of last resort. Domestic investigations and prosecutions could complement those of the ICC. However, it can only exercise jurisdiction over these crimes if the crimes occurred in the territory of a country that is a party to the ICC treaty, and or the persons accused of the crimes is a citizen of a country that is a party to the ICC treaty, and or a country that is not a party to the ICC treaty accepts the court's authority for the crimes in question by submitting a formal declaration to the court, and or the United Nations Security Council refers the situation to the ICC prosecutor. So I tried to draw an outline on some of the questions arising out of the Russia and Ukraine on the international law. But prima facie, it looks like that the machinery of the international law is breaking down. Though some countries tried to put some sanctions, but they have failed. Peace talks are going on. NATO is actively involved, EU is actively involved, the West is also actively involved, but nothing seems to be working. I pray that the situation comes under control and the international law prevails. And I wish the best for the civilians of Ukraine. Thank you for watching the video. I'll see you soon in our next vlog. So stay tuned. Thank you.